Okay, welcome back. This is the next video in our series of MBE videos. This is intended for students studying for the bar exam. A JD exam would be much more detailed, and even for purposes of the MBE, I'm not hitting up all the issues. Unfortunately, I can't talk 24 hours in a row. So we're picking and choosing the issues and even the level of detail. The next topic here is going to be pleading. And particularly I'm going to start off with what you need to do in order to state a claim that would withstand a motion to dismiss for failure to state a claim. First, you need to note the connection between Rules 8A2 and 12B6. 8A2 says a pleading, putting forth a claim, must have, among other things, a short and plain statement showing entitlement to relief, right? 12B6 says you can obtain dismissal for failure to state a claim. So in other words, a deficiency under 8A2 is a basis for dismissal under 12B6. Now, 12B6 dismissal can come in two flavors. One is legal insufficiency, and the other is factual insufficiency. Legal insufficiency, simply put, is even if all the facts are true, even if there's sufficient facts, the law just doesn't provide a remedy. So the example I always use with my JD students on the very first day of class is willful and malicious. What is it? Failure to invite. JD students, where are you? Okay. Willful and malicious failure to invite. I sue you and say on such a date, you had a birthday party, I really wanted to go. You didn't invite me, you told me you didn't want to come. I said you'd hurt my feelings. You said too bad, so sad. You didn't invite me, and now I'm suffering pain and suffering all of that. Boo-hoo. I put in lots of facts, okay? But guess what? Unless something's changed since I started going to law school, you can't sue somebody for not inviting you to their birthday party unless you have, say, like a contract or something. There's no tort claim for that. All right. So even if there's lots of facts, we have legal insufficiency here. Law does not provide a remedy. What you're more likely to be tested on is factual insufficiency. And even then, I'm only going to get into so much more detail because it's a little hard to test this on multiple choice. All right, factual insufficiency, we're in Iqbal territory now, right? You sue somebody for negligence and you say, oh yeah, you know, you were negligent and hurt me, right? Well, that doesn't tell the defendant very much, right? So even though the law does provide a remedy, so the problem isn't a legal insufficiency. You can't just sue somebody and say, hey, yo, you were negligent and therefore you owe me money, okay? That's going to be a problem of factual insufficiency, right? That's the problem here. Now, how do you analyze a 12B6 motion regarding factual insufficiency? Well, the first thing you need to look at is, did the complaint provide the defendant with fair notice, right? Did the defendant get fair notice? Are there enough facts in there regarding what they're being sued for and what the legal theory is and the times and the dates and all of that? Is there enough information in there so the defendant can start preparing a defense on the merits, right? Now, if I sue you and say, oh, you were negligent and you therefore harmed me and therefore I want over $75,000 exclusive of interest and costs, you have no idea what I'm suing you for. It could be slander, or it could be copyright infringement, or it could be negligence or a breach of contract. Who knows, right? So you got to give fair notice. And that comes from Conley, actually. That's a part of Conley that's still good law. The second part is the more troublesome part, which is the Iqbal and Twombly part, the showing entitlement to relief, the so-called plausibility standard. All right? And there's two steps to the plausibility analysis, and the second step has two additional steps. The first step, under Part 2, is to separate the facts from legal conclusions. All right? So, for example, legal conclusions would be the type of language that you'd expect to find in any complaint, right? The defendant breached a duty of reasonable care towards the plaintiff, right? That's just a legal conclusion, right? Facts are more likely to be dates, names, things people did. The line between fact and legal conclusion really isn't all that clear. And academics criticize Iqbal for that reason amongst others. But try to separate facts from legal conclusions, all right? And then it's like a filtering mechanism, right? Ignore the legal conclusions. Now we just have the facts. And in the second step, part 2B, you then ask whether or not the claim is plausible. And here you only look at the facts, just the facts, and you use your so-called judicial experience and common sense and ask whether or not the claim states a plausible claim for relief. Now that really doesn't tell you very much, right? That's a kind of a meaningless standard. So let's try to flesh this out a little bit. Supreme Court tells us the plausibility standard doesn't rise to the level of showing that the plaintiff is probable to succeed, but that a mere possibility is not enough. So you kind of have like a baby bear standard here, right? Plausible falls somewhere between possible and probable, but the lines between these three terms are extremely hard to measure. So it's a terrible standard, but this is what has to be shown. Now let me illustrate this with a hypothetical, with an example that fleshes out in a more realistic way how you would analyze something like this. Remember, what we're talking about with an Iqbal fact pattern is there's a factual insufficiency. All right? So say, for example, you have a complaint that cites some facts, but there's holes in the facts. For some of the elements of the cause of action, facts are provided, but for one or more of the necessary elements, facts are just flat out missing. For example, in the Iqbal case itself, you know, there was allegations of discrimination, right? Of discrimination. But the discrimination allegations were kind of conclusory. How about Twombly, where telephone companies were accused of entering into a contract or conspiracy in restraint of trade? But the trouble was, all of the allegations regarding the contract or conspiracy were legal conclusions. And in the end, the only facts were left were the facts that the phone companies had all acted similarly to one another. Does the fact that they were acting similarly, is that enough to show that a plausible allegations, enough to show that the missing link, the missing fact of a contract or conspiracy, was that plausible? Let me give a much more straightforward fact pattern. And by the way, you will find this on my website. So click on courses, Civ Pro, Civ Pro study materials. Then click on pleadings and look for the hypos involving Iqbal and all of that. They're the Meg, Stewie, and Brian hypos, you know, the characters from Family Guy. So imagine that Meg is driving down the road, all right, and all of a sudden a blue Toyota Prius smacks into her, all right, and then drives off. She doesn't get the license plate. She doesn't see the face of the driver. All she sees is the driver is drinking something out of a paper bag. So here's what she alleges, all right? I was hit by someone driving a blue Prius, and I didn't see who was driving with their license plate, but I saw they were drinking something from a paper bag. And by the way, Brian, you know Brian, he's the dog from Family Guy, right? All right, Brian drives a blue Prius, and Brian has a drinking problem. Accordingly, he was negligent and owes me all this money. Now let's think about it. What are the elements of negligence? Duty, breach, cause and fact, proximate cause, and damages, right? Duty is determined by the court. But what's the problem here? There's no allegation of breach, is there? No allegation that Brian was the one driving the car. There's a hole in the facts. We have factual insufficiency here. So what do? We filter the facts from the legal conclusions. So we take out the allegation that Brian was negligent, all right? Because that's not a fact. That's rubber stamp stuff, right? That's boilerplate. We're left with the facts that Brian's a drunk who drives a blue Prius, Meg was hit by a blue Prius, and whoever was driving the car was drinking something from a paper bag. Okay? Now, what can we infer from the facts? Can we infer that Brian was driving the car? Is that a possible inference? It's possible. Is it also possible that somebody else wasn't? There was somebody else? Exactly. And I can see from your actions where your thinking is going already. Now you intuitively understand what Iqbal is about. All right? All right? Now, is it possible that Brian drove the car? Yeah, he's a drunk. and he drives a blue Prius, and whoever was driving the car was drinking something from a paper bag. Maybe it was liquor. So a drunk driving a Prius, maybe that was Brian, right? On the other hand, using your judicial experience and common sense, your life experience and common sense, well, how many blue Priuses are there in the road? Like more than one, like lots, right? Just in Florida, there must be thousands of them, right? So what's more likely? Brian drove the car that hit Meg, or somebody else did? Yeah, somebody else. All right. It's possible that Brian drove the car. It absolutely is, but it's not plausible. Now, how do you tell the difference between possible and plausible? And here's how you do it. There's a hole in the facts, right? Here, Here's one inference. It was Brian. Here's another inference. Somebody else. All right? Let's say here's the inference that someone else did it. This is from unlikely to likely. All right? Where would you end the line for Brian? Okay? Tell me when to stop. Tell me when to stop. Stop. Ah! Which one's more likely? This one. All right, we have a hole in the facts. We take the facts, we draw inferences, we use our common sense as living people. Use our common sense. Which one's more likely? If this one is more likely, say the inference goes up to here, okay, the inference of liability is greater than the inference of non-liability, then the claim is plausible. On the other hand, if the inference of liability is equal to or less than the inference of non-liability, then liability is possible, but possible doesn't cut it anymore. You have to be plausible. Plausible meaning that the inference of liability is more likely than the inference of non-liability. That's Iqbal. Let's move on. Not much else to say about Rule 8. You might be tested on the answer portions of Rule 8, right? I mean, you sue somebody, and if they serve an answer, then they got to, admit or deny. The answer contains three things. Admissions, denials, deemed denials. Also can contain counterclaims and cross-claims, and can contain affirmative defenses. And affirmative defenses include the defenses in Rule 8C, contributory negligence, waiver, stuff like that. And can also include any Rule 12b defenses that are still valid, right? All right. But let's talk just for a moment about the answer itself, okay? You admit, deny, or deem denial, right? So you got to admit or deny or deem deny all allegations, and anything you don't admit or deny will be deemed admitted unless it goes to the amount of damages, okay? Now, when you do your answer, you got to do your Rule 11 investigation, right? And if something's true, you've got to admit it. Now, you can't just have a general denial. So if the defendant sues you, the plaintiff sues you and says, you did this, that, and the other, and the other, the other, and this, you did A, B, C, D, and E, and you've done A, B, C, and D, but you didn't do E, you shouldn't be answering by saying denied, all right? Because the rule tells us very clearly that if you intend to admit in part and deny in part, then you have to admit in part and deny in part. You can't just deny everything because one thing is wrong. Okay, so be careful with that. Another thing to keep in mind is it's possible to do what's sometimes called the deemed denial, which is after your investigation, you've realized that you went through what you know and you went through the information that's available to you, but you just don't have a belief one way or another. Well, then you're allowed to answer by alleging defendant lacks knowledge or information sufficient to form a belief, and that then will be treated as a denial. All right, so you can do that as well. I guess one last thing to note about Rule 8 and Rule 9 is Rule 9 covers specialized pleading scenarios, right? And the big one that I think that you might be tested on is Rule 9b, which involves specialized pleading standards for allegations of fraud and mistake. There's a whole interesting body of case law that's just beyond the scope of what I can reasonably cover, so I won't. But I will go over the basics of Rule 9b, which tells us that states of mind can be alleged generally. State of mind, intent, knowledge, things like that can be alleged generally. However, the circumstances of a fraud and the circumstances of mistake, something you understand now that you've had contracts, circumstances of fraud and mistake must be alleged with particularity. Okay, so for example, if you're going to sue somebody for fraud, you can't just say, you know, Nathanson defrauded me. That's not going to cut it. You're going to have to go into more detail. You know, for example, what was the misrepresentation, right? How was it a misrepresentation? When was it made? Things like that. So the trap that you might see on the bar exam is a fact pattern that, you know, gives a short and plain statement of the claim, but is quite conclusory on fraud. Among other things, that may raise problems under Rule 9b. All right, now let's, one or two other issues with pleadings, and we'll close that out. I'd like to talk about Rule 15. And there's a bunch of stuff in Rule 15, but I'm only going to focus on two things. The first is going to be amendments, and the second is going to be relation back. All right, amendments. Amendments under Rule 15a can be done in three ways. Matter of course, by a consent, or by leave of court. All right? Now, amendments as a matter of course is something that I could completely see you getting tested on this. An amendment as a matter of course is a one-time mulligan. You know what a mulligan is? It's a do-over. You know, well, I screwed it up, I'm going to do it over again. So it's an amendment as a matter of right. Matter of course is the technical term. You only get one amendment as a matter of course. One and only one. All right? And the timing runs, there's two ways that it can be done, but you still only get one shot. You get up to 21 days after you've served a pleading. You have that absolute right to amend it, as long as it's your First Amendment. 21 days after you've served it. Or if the pleading that you served is a pleading to which someone else has to respond, then you can also amend as a matter of course within 21 days after the opposing party serves their responsive pleading or serves a motion under Rule 12. Okay? So, for example, I serve my answer on you. You sue me, and then I serve an answer where I deny a bunch of stuff. And then I realize that I forgot to include a defense. Okay? Well, you sued me, I answered, I included no counterclaims, so you don't have to respond to that plaintiff. And I realized that I made a mistake in my answer. Well, I have up to 21 days after I serve my answer to amend it as a matter of course. I don't need your consent, plaintiff, and I don't need the permission of the court. Here's another example. Plaintiff serves a complaint, okay, and then the defendant answers the complaint 21 days later, okay? And now the plaintiff realizes the plaintiff would like to add an additional cause of action into the complaint. Well, it's too late to amend as a matter of course under the first definition of matter of course, which is 21 days after you serve your complaint, or serve your pleading, right? However, you also have up to 21 days to amend your pleading as a matter of course after the other person has filed a responsive pleading to your pleading, right? So I serve my complaint, you answer. Well, now I have up to 21 days after you answer to amend my complaint as a matter of course. Now you only get one, okay? Regardless of what the timing is, you only get one. And after that, you know, you're going to have to ask for permission from the other parties. That's consent, all right? And if it's too late to get matter of course, too late to get consent, then you can always ask the court's permission. It's a motion, leave of court. The rule says, leave to amend shall be freely granted as justice requires, right? So courts tend to err towards giving amendments. It's in the court's discretion, but they tend to give leave to amend, especially when it's early in the litigation. Courts will look to things like whether there's been undue delay in seeking to amend, whether the amendment would be unduly prejudicial to opposing party. The court will also look to whether or not the amendment would be futile. If the amendment would be futile because it doesn't state a claim or because it would be time barred, then the court might just flat out deny leave to amend. All right, so that's amendments. Last topic on pleadings is going to be one of my favorites. Just tested on it a couple weeks ago. Relation back. And relation back deals with statute of limitations facts patterns. Relation back is like super duper testable, right? And the thing that I think is particularly likely to be tested are going to be the timing requirements regarding relation back. Well, relation fact pattern is going to involve there's a pleading, and then a statute of limitations is going to expire, and then there's going to be an amendment after the statute of limitations has expired, right? Well, the question is going to be, does relation back save the pleading? So here we have filing of the initial complaint before the statute of limitations expires, and here we have the amended complaint, right? Well, the amended complaint is after the statute of limitations expired. It's done. It's cooked. It's history. Unless we can go back to the future, right? Unless this amended complaint relates back to the timing of the earlier timely pleading, right? So how do we analyze relation back? Well, there's a number of elements, all that must be met in the conjunctive, okay? There's a number of issues here. I'm not going to get into all of them. We just don't have the time for that. So I'm going to get into the two main bases. First one is under Rule 15C1B, and the second one is Rule 15C1C. All right? 15C1B is when you got the same parties, okay, but someone is adding or changing a claim or defense, okay? That's the scenario where 15C1B kicks in. And here's the question, here's the rule that you need to analyze. CTO is what's pleaded in the new pleading, say it's a claim, say we add a claim, does the new claim arise from the same conduct, transaction, or occurrence as the earlier timely pleading? So for example, I sue somebody for negligence, okay, regarding the manufacturer of a guitar. I buy a guitar from someone, I have them custom make it for me, and they did a crappy job, and I sue them for negligent manufacture. And then after all the relevant statutes and limitations expire, I want to add a claim for breach of warranty, okay? Well, did the breach of warranty claim arise from the same conduct, transaction, or occurrence as the original claim for negligence? And here we're comparing one thing to another, right? Is the claim for negligence sufficiently similar to the claim for breach of warranty? We're going to look to similarity in evidence, right? Whether there's a logical connection between the two. The time when things occurred. Do they occur at the same place, different places, close in time, far away in time? You know, it's very factually contextual, all right? Now the fact pattern where 15C1C kicks in is where we're changing a party, either their name, changing a party or the naming of the party, or even adding a party. So for example, I sue person X. So it's Nathanson versus X, okay? And then after the statute of limitations expires, I want to add Y. So now it's Nathanson versus X and Y. Well, in this scenario where we're changing a party, changing the name of a party, or even adding a party, all right, there are many more elements that need to be satisfied, and it's a lot more complicated, which makes it a lot more testable, because now we have timing requirements. All right, well, here's the rule. First, CTO. Whatever I'm suing the new people for has to arise from the same conduct, transaction, or occurrence as what the earlier timely pleading alleged. Second, there's a timing requirement. That's the timing requirement under Rule 4M of the Rules of Civil Procedure, which is 120 days after the original filing. Okay? 120-day period after the original filing. Within that 120 days, two things must occur. First, the person to be added or changed must have notice such that they will not be prejudiced in defending on the merits. And the second is they must know or should know that they would have been named to the earlier pleading but for a mistake. Okay? Let me just think for a second. Yeah. Now I'm not missing anything. All right. Now this is really important. The CTO is just incorporating this analysis into this one. We want it to be the same conduct, transaction, or occurrence. But what's interesting and testable about 15C1C is it has this requirement that two things have to be obtained within 120 days of the original filing. Okay, I'll talk about the timing in a minute, but let's talk about the two things that have to happen within 120 days. The first is, however the person to be added or changed finds out, they've got to get some sort of notice, either formal or informal, that, hey, guess what? You might be sued, and therefore you better start preparing your defense. So as long as that notice is in enough time so they can start preparing a defense, getting a lawyer, gathering evidence, talking to people, then that element's going to be satisfied. And the last element is the defendant to be added or changed has to realize something, or ought to realize something, that, hey, I would have been sued earlier had the plaintiff not made a mistake by not naming me, right? You know, that's that kind of like, uh-oh moment. Like you're on notice and you think, oh crap, I'm next. Whoa, if they had known everything they ought to have known, you know, then I would have been named earlier on, right? And the Supreme Court in Krupski tells us the mistake, you know, it's defined pretty broadly. You know, it could be ignorance, lack of information. Justice Sotomayor says that, you know, the plaintiff might make a mistake even if the plaintiff knows of the existence of the unnamed party, so long as the plaintiff didn't understand the role played by that party. So in Krupski itself, you know, Mrs. Krupski sued Costa Cruise Lines, and she apparently knew about Costa Crociere, the proper defendant, but didn't sue Costa Crociere because the ticketing materials were ambiguous and unclear as to who was actually responsible for any tort liability, right? So you can know about the existence of someone, but still must misunderstand the role they played in the liability creating conduct, and that could still be a mistake, all right? Well, now think about it. CTO, very factually contextual, right? Notice, preparation time, very factually contextual. Know or should have known but for a mistake, very factually contextual. You know what's not factually contextual, not debatable, what's like kind of bright line, is the 120 days. That's where they're going to get you, in my opinion. So let's look at that, and that'll wrap up pleading. Here's what you got to do. You get a fact pattern like this, get out a pen and a paper and draw a little chart. All right? All that matters here is when did the statute of limitations expire? Okay? When was the original complaint filed? And add 120 days. Okay? Add 120 days. Then you ask, are there facts showing that the defendant to be added or changed got that notice or knowledge, right? For example, the facts tell you they read an article or they saw a copy of the complaint that was served on their buddy, right? They got notice and then they have that uh-oh moment. They realize they're like, oh, I'm next, right? What we care about is when did they get that notice and knowledge, right? Did it happen here or did it happen here? A or B? If that, in fact, let's do it this way. Here. A, B, and C. All right? And let's assume the amended complaint is filed all the way over here. All right? Now, our earlier picture was the complaint was filed here, right? And the amended complaint is filed here. Is the amended complaint timely? No, right? Unless it relates back to over here, right? So we have to ask, was the notice or knowledge within the 120 days? right? Look at scenario A. Notice of knowledge is within 120 days of the original filing, okay, and before the statute of limitations. All right? Assuming, same CTO, assuming notice and knowledge satisfy these elements, all right? Well, in scenario A, the amended complaint will relate back, right? Because the notice of knowledge was within 120 days. Now look at B, all right? Notice and knowledge are within 120 days, but fell outside of the statute of limitations. Guess what? Still relates back, because the notice and knowledge were within 120 days. Now, how about number C? Notice of knowledge are way over here, all right? More than 120 days. Will the amended complaint relate back? Nope, because the notice of knowledge were outside that 120 days. Now, there's additional scenarios and permutations that I could share with you, but I'll limit it to this right now, right? So look for, whether there's that kind of information that comes to the person to be added or changed. There's like, I guess I have time to prepare and have that, I'm going to be sued moment. Well, when did that moment occur? Was it within 120 days of filing, right? If so, then the amended complaint that's way over here will relate back. And so long as this earlier filing was in time for the applicable statute of limitations, relates back. We're good to go. And that's what I think you might be tested on. So anyway, that's pleadings, and so we're going to move on.